these are unprecedented times. According to a recent University of Illinois, Harvard, and University of Chicago study, more than 100,000 small businesses have permanently shut down since March of this year. 34% of small businesses said they are either paying reduced rent or delaying the payment, according to a poll conducted in late April. According to the National Restaurant Association, 3% of restaurants have gone out of business. A recent article in the Washington Post found that only 4.2 million of the nation's 30 million small businesses have received emergency loans from the SBA. According to the American Bankruptcy Institute, as many as 25,000 retail stores may close in 2020. And according to Mark Zandi, chief economist at Moody's Analytics, over 1 million micro businesses, that means businesses with fewer than 10 employees, may ultimately close. Indeed, it is very challenging to run a business during these times. Some businesses have been net gainers, most have not. While creditors were generally understanding during March, April, and maybe May, this is unlikely to extend to June and July. There is increasing pressure on businesses, and some of you may have businesses or affiliates where the thought has crossed your mind that you might have to file for bankruptcy or insolvency or some other insolvency proceeding. That can seem like a very scary process. We are here today to demystify that process a little bit for you. In Ernest Hemingway's The Sun Also Rises, Bill Gorton asked Mike Campbell, quote, "How did you go bankrupt?" To which Mike replies, 2 ways, gradually and then suddenly. When creditors come at you from multiple directions, when your cash is tight and you cannot make payroll, when you have no more PPP loan proceeds, that means payroll protection plan loan proceeds, things can get very uncomfortable. In this webinar, we will discuss 1, what to do and not to do at the first signs of financial distress. 2, what an out-of-court workout is and why it might benefit your business. And we always recommend bankruptcy as a last resort, and you'll hear that over and over again today. 3, what an assignment for the benefit of creditors is and why it might be a viable alternative to bankruptcy. And lastly, 4, what are the types of bankruptcy available and how would each affect your business? We are also going to be discussing what steps you can take when negotiating with your commercial landlord and what measures you can take for negotiating with your bank. Well, I'm proud to have on the panel today with me Mike Cortina, who is the co-chair of our financial services practice, overseeing the team providing financial institutions with advice and representation on transactional and litigation matters throughout each of the firm's 7 offices. Mike is the attorney to call for banks across the Midwest. He has extensive experience representing banks in all types of litigation. Mike is a member of the Illinois State Bar Bench and Bar Section Council and formerly of the Real Estate and Commercial Banking Section Councils. Mike is also the author of numerous professional publications on this topic. Also joining me, I'm proud to have Bill Hackney. Bill is a member of the firm's financial services group, concentrating his practice in the area of insolvency, restructuring, and creditors' rights. Bill has significant experience representing debtors, lenders, secured creditors, creditors' committees, trustees, and other parties in Chapter 11 and Chapter 7 cases, as well as out-of-court workouts and restructurings and related litigation that accompanies the same. He also acts as outside bankruptcy counsel to a number of business entities and provides general business counseling in distress situations. And my name is Eric Fogel, and I am chair of the Corporate and Securities Practice Group. I've been practicing 36 years and work on all work with all kinds of companies that are undergoing all manner of restructuring and insolvency situations. I closely advise chief executive officers, board members, and general counsels throughout the nation and have handled capital transactions involving hundreds of millions of dollars. I often work with my clients in an outside general counsel capacity. Okay, so let's get right into it. Mike Cortina, I have a manufacturing business. While my landlord has been good to me during the last 2 months during COVID, my landlord is now coming at me hard, and I'm concerned about being locked out of my business facility and the landlord foreclosing on all my equipment and other assets. What can I do?
Thanks, Eric. I appreciate that. Well, there are a lot of things that can be done, and I'm going to be repeating this over and over. The one thing that is more important than anything else, I believe, is to maintain the lines of communication with the landlord and also with the lender, if we're talking about a bank. And these sort of things, they're going to keep happening. Eric's example is not one that is going to be a one-off. As the slide shows, unemployment is over 13% right now. COVID-19 has decimated businesses. PPP funding, if you received it, still can't be used on anything you want and still be forgiven. It's very, very much expected that businesses are going to have difficulty paying rent. And so we need to know what is possible regarding evictions. So next slide, please. So what I'm going to talk about here in answer to Eric's question and also to other questions in general, I'm going to talk about the eviction statute, eviction litigation, and tips for dealing with evictions. And then I'm going to finish off with answering some frequently asked questions on banks. Next slide, please. Now, I'm only going to be talking about commercial evictions. Consumer or residential evictions are a completely different kettle of fish from commercial, and we would spend way too much time, so I'm just going to talk about commercial. Next slide, please. Next slide, please. The statute, the eviction statute, is the only method that landlords can use to recover possession of real estate. In Eric's example, worried about the landlord, changing locks or something like that. Ways of recovering real estate, like changing locks or cutting off utilities, or chaining up a building to prevent access. That is illegal. That is not allowed in Illinois. And one takeaway from this, easy way to remember it, is that there's no such thing as cowboy justice when it comes to eviction. Next slide, please. Now, the purpose of this statute, the reason we talk about it, is because it's intended to resolve possession of real estate, disputes about that. Litigation is limited to the issue of who's entitled to possession. Landlord can also, under the statute, bring a claim for any past due rent or possible future rent in the case. And a tenant can submit defenses to a case, but those defenses must be germane to the case under the statute. Next slide. Now, when is it germane? It has to pertain to possession of the property itself. And there are 4 categories. Claims asserting paramount right of possession. Tenant saying, no, I have a right, not you, Mr. Landlord. Claims denying a breach, saying, no, I did not breach the agreement. Claims challenging the enforceability of the lease itself. Or claims questioning the plaintiff's motivation for bringing the action, saying, oh, this person is really just trying to evict me because they've got somebody who's willing to pay double what I'm paying, so that's why they're really trying to evict me. I'm not really in breach. Those are the 4 general categories of what is germane. Next slide. So here's an example case, an actual case I was involved in. Landlord believes that tenant failed to pay full rent, and that's because part of the rent was based upon a percentage of sales of the tenant. So the landlord went out and changed the locks and prevented the tenant from entering the property, actually then turned around and left town for a week. And then when he got back, filed an eviction action. The tenant filed a counterclaim against the landlord to evict the landlord from the premises. because the landlord is now in possession since the landlord changed the lock. That counterclaim is a germane counterclaim. It's obviously relative to possession of the property. Next slide. And here's an example of something that is not germane. Landlord sues to evict due to lack of payment, and tenant counterclaims for defamation, saying the landlord posted the tenant's name as a deadbeat loser tenant with flyers at every commercial building surrounding the tenant's location. That issue of defamation, it's an issue, but that would not be germane to possession of the property. So if that counterclaim, it would be dismissed by the court because it has nothing to do with possession of the property. All right, next. Eviction litigation. Now, in order for be sued for eviction, they must be served with a notice by the landlord demanding possession. This is an absolute requirement. And failure to serve notice on a tenant is fatal to a landlord's eviction action. Now, the lease agreement itself may alter how notice can be served. It doesn't have to necessarily be done in accordance with the statute if the lease says we're agreeing that notice is going to be done this way. But then service must be done in accordance with the lease. And the lack of compliance with that is fatal to the eviction action. Now, as an example, next slide, please. Again, actual case I was involved in. A lease required all notices to be sent to a tenant at a certain address, not the address that's being rented, but a different one. But the notice that the landlord sent was just sent to the lease premises. The court held that the landlord's failure to adhere to the lease's requirement for service of the notice required that judgment be entered in favor of the tenant. And this is a big retail tenant. This is a case involving a wood mall and a tenant at the mall. And the failure of the landlord to actually serve notice properly resulted in the tenant winning the case for eviction. Next slide.
Mike,
yes,
this
sir.
is Eric. If I could just ask you a question, it might be on the mind of the audience. How long do evictions take generally under the statute? And then secondly, it's been in the press that courts, for instance, in Cook County are not yet quite open for business. So are any evictions actually happening these days?
Okay, thanks. Evictions are supposed to be what are called summary proceedings. Usually they're set for trial within just a few weeks of when the court date for the return of summons happens. So it's not uncommon for a eviction trial to be held, say, 14 days after a first court appearance because they are summary proceedings. Now, regarding Cook County in particular, the current rule in 11 days, I'd look at the date, residential evictions can possibly be started again. Commercial evictions, they cannot be initiated right now. You can file it, but that's about it. You can serve the summons, but then everything is coming to a halt. And right now, the next 28 days, the sheriff is actually not going to execute on any orders for possession. So the sheriff won't actually remove anybody right now. This changes on a daily basis, and very well could be tomorrow, everything changes. But right now, things are kind of at a standstill. That will be changing probably very soon, especially as Illinois moves into the next phase of reopening. Now, regarding trials, even though they are supposed to be summary proceedings, the parties do have a right to conduct discovery, just like any other case. So depositions and things like this are allowed. So sometimes those things do present some sort of procedural delay in the case, but they are still supposed to be summary proceedings and occur very quickly. Next slide, please. In general, it's just like any other civil case. Defendants are able to answer a complaint just like anything else. Next slide, please. Now, there's no statutory right to a jury trial in a commercial eviction, but that's actually kind of irrelevant because almost every commercial lease I've ever seen has a waiver of jury trial in it. So even if there was a right, everybody agrees that it's not going to happen. So any trial would just be in front of a judge. And corporate defendants, I hate to say this, and don't just consider the source, this is actually just the law, they have to be represented by an attorney and cannot be represented by an officer of the company unless the officer is also an attorney. Now, the president of the corporation, she may be an absolute genius, but if she is not licensed to practice law in Illinois to represent the defendant, if it's a corporate defendant, would be licensed and is simply not allowed. Next slide, please. Judgment for possession by the landlord. Give the tenants a reasonable amount of time to vacate the property, and what is reasonable is on a case-by-case basis. I've seen everything from 7 days to 60 days and everything in between, so different. If the tenant does not vacate the property after being ordered to do so by the court, again, there is no cowboy justice. The county sheriff has to order possession, which, like I mentioned earlier, right now the Cook County Sheriff is not doing. That'll change, though. But when the sheriff does do this, they don't go out there and carry things out. All they do is they show up, knock on the door, say, we're taking possession of this property, and they're there to keep the peace. And the landlord has to have movers there to remove all of the tenant's property. All right, next slide. Eviction case tips. Again, lines of communication are very important. Most evictions can be avoided by negotiations between a landlord and a tenant. Now, both sides have to be willing and able to have communications. If one side is obstinate and does not want to talk, and that's not going to help. But the worst thing any tenant could do is refuse to have any kind of discussions because that's automatically going to lead to an eviction. Next, the commercial lease itself often has rights reserved to landlords and to tenants. That can be a basis for an eviction or a defense. So review of the lease is very important for dealing with anything like this. Third, landlords are required to, as we say in the law, mitigate damages. So they can't sit there and evict somebody to a 5-year lease and sit back and wait and say, well, you know what, they've got to pay me rent the entire 5 years because that's what the lease said, and sit back and not try and find a new tenant. No, they are required to try and find a new tenant. As we say, mitigate or decrease damages, lessen them as much as possible. Fourth, courts dislike evictions based on default other than non-payment. Mostly I'm representing creditors, and mostly I'm representing landlords. I do not want to be the attorney who goes into court and tells the judge, yes, judge, they have made every single payment on time to the entire amount of the lease, but they didn't shovel the snow off the sidewalk as is required in the lease, so I want to evict them. The judge will sit there and say, something smells fishy in the state of Denmark, and then say, you know what, every inference will be in favor of a tenant. And so courts just dislike that type of eviction. Finally, have a lawyer review the lease if eviction is imminent. I know, again, I'm a lawyer telling you this, but at the same time, it is absolutely true. Most people sign leases. You can even have read it over. Most don't, but if you've read it over, there may be some legal issues and nuances in that lease that most people kind of gloss over or simply just don't understand. And it may be in there and you simply don't know it. So having a lawyer review the lease if you think there's any issues going on with possibly being evicted, that's key. All right, next please. All right, switching gears a little bit. Frequently asked questions about banking. I'm going to go through these and then kind of say the question and then the answer. First, does the bank just want my property? Simple answer is no. Banks do not want your property. They don't want your equipment. They don't want your inventory. They don't want your commercial building. They are in the money business, not in the bulldozer or jewelry or commercial property business. They just want to be paid. So the idea that they're just trying to take my property, that's not accurate. Now, is it better to not answer the phone if my bank calls? That is the absolute worst thing you can do. Again, lines of communication are important. If a borrower does not communicate with the bank when the bank is calling, then the bank says, well, they're not willing to work with us at all to try and get this resolved, and they have no choice but to move forward with a lawsuit, foreclosure, what have you. Next, what is a workout or a bank's workout department? That's just what it sounds like. A workout is there is a loan that is not proceeding as it should be. There's some sort of problem with it. So the bank tries to work out that problem with the borrower. And sometimes banks do have separate workout departments. They have different names. Special Assets Group, for example, is one of them. And so those are people who, that is their job to work out deals with loans that are not exactly doing the way they should be going. Forbearance agreement, just what it sounds like. Again, it's where the bank agrees to forbear or not execute on one of its rights. Say somebody is not able to make a payment and the bank is willing to say, okay, I'm going to take interest-only payments for a few months until COVID-19 ends, for example, and then get back on track. That is a forbearance agreement. The bank is forbearing on executing on calling the note and filing suit. Can a bank take money account if I miss a payment? Most people are surprised by the answer to this, but the answer is yes. If your accounts are at that bank and you miss a payment, banks have a right of set-off where they can take the money out. Not only does that exist under the common law in Illinois, but generally it's also in the loan agreement, and it's usually also in the account agreement itself. It has happened, and it will continue to happen.
Mike,
Yeah.
This is Eric.
Yes,
if I could just ask you a quick question. So what about a payroll account? So if a company puts money into a payroll account, can a bank freeze that as well or seize it?
Yes. Thanks, Eric. And yes, the bank can seize that. The fact that it's a payroll account doesn't matter. The common law right of set-off, specifically, it doesn't specify the type of account it must be. So if it's a payroll account, that account can be seized by the bank if there is a loan default and the bank exercises its right of set-off.
Okay,
that
thank you.
Automatically begs, no problem. That begs the question, well, should I just then move my account to another bank? Well, you could. That is a possibility. When that happens, the signal that the borrower is giving to the bank is that they intend to try and shield assets, hide assets, prevent the bank from being paid, and not engage in communications with the bank. Again, it can be done. All you're probably doing, though, if something like that happens, if a borrower does that, all that borrower is doing is signaling to the bank, you need to go ahead and start executing, call the note, and do what you can to try and collect on this because I'm not going to be cooperative. Next is, can a bank then come take all of my inventory and equipment? Banks don't like doing this. Again, they're not in the inventory or equipment business, but yes, actually they can. If you've granted, or if a borrower is granted a security interest in their inventory or equipment in order to get a loan, says I grant the bank a security interest in the security agreement on loan documents. Then in Illinois, under certain situations, if, say, for example, a business is located near a state line, like the entire city of Chicago is, that is one of the criteria. If you have something that can be moved easily across the state line and the bank is concerned about that, and they can demonstrate to a judge that there's a possibility that that actually will happen, they can go to court and get what's called an order for replevin without notice. So they don't actually even have to let the borrower know they're looking for a court order to obtain this property. And the first time that the borrower knows about this is when the sheriff knocks on the door with an order saying, give all this property to the bank official here. Here's a court order for replevin. So yes, it is possible. Doesn't happen in all circumstances. Things have to kind of line up, but yes, it is entirely possible. All right, next slide, please. You may have heard the phrase PFS. What is it? Why does the bank want one? It's a personal financial statement. It's a list of all the assets and debts of an individual or a corporation, and it's sworn to under oath. Why does the bank want one? Sometimes it's part of the annual review of the loan, make sure all the assets are still there, valuations and things like that. Or sometimes it's banks are sort of concerned. How is this business doing? Does it have the cash flow? Does it have the cash to be able to continue making payments? And if they have a concern, and they also might look at this and say, well, what sort of assets are available to us in case we have to go ahead and call the note and file suit in order to try and collect? Then again begs the question, well, in that case, should I just leave assets off of my PFS so that the bank doesn't know about it and I keep them away? Well, let's think about that for a second. Now, this statement is not only a statement to the bank, it's also notarized, sworn to as being accurate. Failure to be accurate is that borrower has just lied to a federally insured financial institution. That is a federal crime to leave anything off of a sworn to financial statement. So should you leave assets off of it? Absolutely not. That's criminal conduct. That happen. Next question. Bank asks me for additional collateral for my loan. Do I have to give it to them? If the loan is performing and within all the parameters of it, bank is not going to be asking for additional collateral. So if there's a problem with the loan, then the bank is asking for it. Do you have to give them additional collateral? No, you do not. However, if you do not give additional collateral to a bank when they're asking for it, which means that there's a problem with the loan, then the bank will turn around and more likely say, well, you won't give us a collateral, you are in default, we are calling the loan, we are now going to file suit. And same sort of situation with the bank asking for an additional guarantee. Why are they asking for it? Again, there's a problem with the performance of the loan. The bank is not comfortable with part of the loan being able to be repaid, what have you, any number of situations. That's why they're asking for it. Again, does it have to be given? No. If it is not given, however, odds are they can just turn around, call the note, and then litigate. What is this called? A judgment by confession. What is that, and can it affect me? Nothing to do with religion. That's what most people think. Judgment by confession is where you sign, it's only allowed in commercial loans, and part of the loan document itself, part of the promissory note says, if I'm ever in default, the bank can get any attorney of record to confess a judgment against me. Basically turn around and say, yes, the judgment for X amount of dollars can be entered against me. They sign that, the bank takes that, gives it to a lawyer, they file that in court, and bam, automatically you have a judgment against you, and you don't even know it exists. They don't have to tell you about it. The first time that a borrower learns about a judgment by confession is when the bank attempts to execute on that judgment, tries to collect on it. And then that's a whole new process that starts over. Again, only allowed in commercial loans, and it's only allowed if it's actually specifically in the loan documents. Usually, actually, it's in the promissory note where you will find it. Courts don't like them, but if they follow the law, the courts will allow them. Next slide, please. Well, I have to pay for a bank's lawyer. More than likely, the loan documents themselves have language in them saying that the borrower lawyer if the bank ever has to hire one regarding this particular loan. So it will be in those loan documents. Then the question is, well, can I get the bank to pay for my lawyer? Probably not. Those loan documents are usually crafted by the lender itself, and that fee shifting language, as we call it, is almost always one-sided, so that you'll always have to, the borrower will have to pay for the bank's lawyer, but the bank will not have to pay for the borrower's lawyer. And the last question, look, bank's lawyer sent me a letter, what do I do? We all know the answer to that. Turn around and send it to your lawyer. You don't need me to tell you that. Eric, that's about all I've got for the frequently asked questions. Any other questions before we move on to your presentation?
No, I think that was an excellent presentation, Mike. Thank you very, very much. Okay, moving along. Yes, the Payroll Protection Plan, the PPP as it's called, is supporting a lot of businesses, but the money is starting to run out unless Congress passes yet another PPP program. The combination of landlord pressure, bank pressure, and payroll pressure can be overwhelming if revenues are down 10, 20% or more, and if your margins are tight to begin with. In 2008, the time of the Great Recession, a lot of great middle market companies unfortunately went under because their revenues dipped by 20% and they had a lot of debt and they couldn't timely pay their banks, their landlords, or their employees. So sometimes the only relief is to seek a remedy under the insolvency and bankruptcy provisions. So I'm going to talk now about alternatives to bankruptcy. And bankruptcy, as we've said, should always be a last resort. So the first alternative is an out-of-court workout. And if you have a small business, and if you have a limited number of creditors, typically one bank, maybe a landlord or two, and relatively few employees, it might be possible to do an out-of-court wind-up of your business if you're going out of business. Now, this involves a lot of communication with your creditors and employees. It involves sharing financial information with your creditors as to how much money you have. And it means establishing credibility and trust with your creditors so you can work out deals with them to get them to accept a lower amount on their receivables. But it can be done. We do those somewhat frequently. But again, it has to be the right situation. The benefit of it is it's out of the public eye. It's not a public bankruptcy filing, and it costs a lot less than some of the other remedies and solutions that we're going to be talking about. Typically, an attorney will work with you in that wind-up process and out-of-court settlement, or it can be a CPA, or it can be a financial advisor who will get you through the process. Okay. The second alternative that I want to talk about today is what's called an assignment for the benefit of creditors, sometimes called an ABC, assignment benefit creditors. An assignment for the benefit of creditors is an alternative to liquidating a business under Chapter 7 or a liquidating plan under Chapter 11. In other words, unfortunately, you have to close the company's doors, or your senior secured lender is making you close company's doors to liquidate all of the company's assets. In an ABC, the debtor transfers all of his assets and liabilities to an assignee who is chosen by the debtor, often in consultation with major creditors like the senior secured lender. But the point here should not be lost, that it is the debtor, it is you, that gets to select who the assignee is going to be. Typically, it's somebody you have a good feel about, somebody that you might trust or your lawyers trust to get the job done in a quick and effective way. The assignee is then charged with liquidating the business by maximizing the value of the assets and paying creditors in accordance with their priority, okay? Secured first, then unsecured creditors like trade creditors, and then and other charges. Next slide, please. The assignee may continue to operate the business for a limited period of time to maximize value, to fulfill orders, might keep a certain percentage of the payroll of the employees going to fulfill orders to generate receivables that can be collected, or to finish work in process. Typically, an ABC is in bankruptcy, and depending upon the circumstances, can be completed within a month, that would be fast, or a few months. There's generally no court supervision in Illinois. So with bankruptcy, you have to run to the bankruptcy court if you're the debtor to get anything done of any significance. In Illinois, you don't. And referring back to the Great Recession of 2008, a lot of these great businesses that went under used assignees and the ABC process. ABCs are generally cheaper than bankruptcy, and the fees for the assignee are negotiated up front. So I was involved in an ABC that involved a business that did about $60 million in revenue. Fortunately, the Great Recession hit, and they had a lot of debt, and they couldn't service their debt. So their senior secured lender asked them to basically prepare their assets for foreclosure and liquidation. And so the company got to the assignee. It cost about $50,000 for the assignee's fees. That's probably on the low side, but just to give you a ballpark about what it costs. But here are some other important benefits, and it goes to reputation. So there's less publicity. And some businesses have been in the area for, decades. And there's no public filings with an assignment for the benefit of creditors. So your neighbors don't know how much you were making or how well your business was doing. Generally, the press doesn't pick it up because ABCs are private. Next slide, please. ABCs do require more cooperation than liquidations under the Bankruptcy Code. So this is a disadvantage of an ABC, just to talk about the cons for a minute. In a bankruptcy, a debtor can rely on the Bankruptcy Code and the judge to help get things done if there are recalcitrant creditors. But with an ABC, there's no judge there. So a lot of it's going to ride on the credibility of the assignee, on your credibility to provide information and transparency as much as possible, and on cooperation. Now, my partner, Bill Hackney, is going to tell you about the automatic stay in bankruptcy. What does that mean? That means if creditors are filing lawsuits against the business, hey, pay up type of lawsuits, in a bankruptcy filing, they're automatically suspended, and no other creditor can file lawsuits against the bankrupt estate. With an ABC, because it is private, creditors can still sue, but here's the good news. No creditor can effect a judgment or take any collateral or seize any collateral except through the ABC process. So while an ABC doesn't have the automatic stay, practically speaking, it winds up in the same place because anybody who sues a company that has an ABC is going to have to wait in line anyway. Another disadvantage of an ABC is that if you get some feisty creditors, they can push the company into called an involuntary bankruptcy, and Bill Hackney will touch on that as well. So if things aren't going well with an ABC, 3 or more unrelated creditors can get together and say, bag it, push this into a involuntary bankruptcy. Next slide, please. So the basic steps of an ABC is it's very much initially in the control of the debtor, because the debtor, namely the company and the company's board, will interview assignees, will select an assignee. The debtor works with the assignee to compile a list of all the assets and liabilities, the trade creditors, the employees. Then there is an agreement that's drafted between the company and the assignee as to what the assignee exactly is going to be doing, kind of like a scope. And then the assignee takes control with the assistance of debtor, frequently in consultation with the senior secured party, typically a bank. What the assignee will do is we'll send out a letter to all interested parties and we'll say, hi, my name is the assignee and I have taken control of all the assets and liabilities of the company. We're here to do an orderly liquidation. If you have a claim, please fill out this claim notice and send it to me within the next 60 days, 90 days, 120 days, and we will try to get you some money. Next slide, please. The assignee's duties are as follows. The assignee owes a fiduciary duty to the creditors, the debtor, to try to maximize the value of the estate. So sometimes if the company has a going concern business, the assignee may conduct an auction, sometimes in consultation with a broker. If the company just has a lot of equipment and inventory, good equipment, good inventory, then the assignee will typically work with an auctioneer and bring in an auctioneer to have a prearranged auction for interested parties to come and bid on the equipment and inventory. Assignees are generally viewed friendlier than Chapter 7 trustees and work closer with debtors and creditors, but assignees are required to act in an independent manner and to try to maximize the company's assets for the benefit of all creditors. The assignee may also analyze creditors and claims against the debtor. So if creditors are complaining that the company and the company's principals took out assets or money right before the ABC in an effort to enrich the pockets of the company or the principals of the company, then the assignee can analyze that claim and think about whether to bring suit against the company's principals. So point being that the assignee is fair to maximize the assets and is supposed to analyze claims against the company and the company's principals. And then after the assets are sold and the money is all accounted for to everybody's satisfaction, then the assignee will distribute the proceeds to creditors in order of priority. And then if any remains, it will go to the equity. Next slide. So we already talked about the liquidation process, but the assignee will review books and records with typically an accountant very carefully to identify assets that should be recovered that might have been taken out of the company, including any preferential payments. This is something Bill Hackney will talk about, that if money is taken out of the company 90 days before the ABC, then that money may have to come back or be clawed back into the company. And if it involves an insider, like the company's owners or officers, that preferential payment period, that clawback period, could reach back to as much as a year. And then my partner, Bill Hackney, is going to talk about fraudulent conveyances as well. So if the company has been complicit right before the ABC in spiriting out assets to affiliates or friendly parties at below market value, that can be deemed to be a fraudulent conveyance, and the assignee may have to bring a claim against the company's officers or principals or shareholders, depending upon who was involved. And the assignee will work with debtor personnel, typically the CFO or the controller, to identify receivables, inventory, complete works in progress, fulfill outstanding orders, as we talked about, to maximize liquidation value. assignee will sell assets, often using an auctioneer or broker. And then, as we said, when funds are collected, the assignee will pay it out to the creditors. Okay, and then finally, to wrap up, ABCs are a very good alternative to bankruptcy if you have a small or medium-sized business with a fairly large group of creditors. The assignee will deal with all the headaches for you. And it's private, that's the key, and out of the public eye. And there's an assignee that you can reason with, that you can explain the situation to with respect to particular transfers. It's not as formal as a judge, as dealing with a judge or a creditors committee. And that's why ABCs are so popular in Illinois, but they're not very well known about generally, because people don't talk about this stuff unless it happens to you. So as I mentioned, bankruptcy is a last resort. And now to tell us all about it is my partner, Bill Hackney.
All right. Thank you very much, Eric. I appreciate it. Thank you, Mike, for starting us off here. Again, as you've heard repeated throughout this presentation so far, bankruptcy is always the last option. And when someone comes to see me about financial distress in their business entity, we do go through all those options before we start talking about the bankruptcy option. But at a certain point in time, those conversations, those negotiations, those other alternatives run out, and you may be left with no opportunity or no other option but to consider a bankruptcy filing. Why might you consider a bankruptcy filing? Ceasing operations. You're winding up the business. You're done. You're throwing in the towel. You don't think there's any more revenue to be gained. You can read balance sheet and the business needs to shut down. A Chapter 7 or even a liquidating Chapter 11 is a great method to do that. Impending adverse judgment or unable to make a payment to a secured creditor. Obviously, once creditors start getting judgments against you and can attach those as liens to your assets or even take your assets, that becomes an issue in terms of the ongoing operations of your business. Unable to pay a key vendor. If you need product A to make your widget and product A is made by one person and you can't pay them, you're not going to be able to get product A, you can't make your widget, and again, that's going to put a damper on the ongoing operations of your business. Finally, unable to make payroll. If you can't pay payroll on a Friday, chances are likely that a lot of your employees may not come to work on Monday. Bankruptcy cases are meant to address those, obviously not on that Friday, but leading up to that potential cash crunch and how to deal with that. Those kind of situations may force you into a bankruptcy if your other options have failed. But how do you even commence a bankruptcy? What does the start of the process look like? On this slide, it talks about initiating by the filing of a petition. A voluntary petition basically is just a snapshot in time of your business and its activities. In addition to the petition, you should also file schedules and a statement of financial affairs. Again, those documents are very detailed. They list your assets and liabilities and a very, very detailed list of those assets and liabilities. Insurance policies, firearms, any and all assets that you might consider, judgments that you might have against other entities, any other way that your business entity might be able to come into money, those will all be considered. The statement of financial affairs will include things like, are there any hazardous property, hazardous substances on the property? Is there litigation against the property or the business asset, the business entity, excuse me. Again, it's a snapshot in time of where that business stands as of the date of the filing of the case. You also see, and Eric highlighted it or hit on it a second ago, which was involuntary petitions. Lots of folks do not know about the involuntary process, and I can't spend a whole lot of time on it today, but as Eric mentioned, there is the availability under the bankruptcy code for your creditors to get together and throw a debtor business into bankruptcy. It is a rare occurrence, but it is used. I have used it on, I wouldn't say numerous occasions, but a handful of occasions over my career, and it can be a very powerful tool for creditors, so be aware of that. But when you're filling out these the schedules and statement of financial affairs, and really any document that needs to be filed in regard to a bankruptcy case, I want you to pay attention to that last bullet. Must be thorough and accurate. Mike Cortina talked a little bit about leaving assets off of personal financial statements. And the same goes true here in the bankruptcy context. I cannot stress enough what a bad idea it is to not be thorough, to not be accurate, to not be 100% truthful on these things. In addition to Mike's mention of criminality, it is a federal crime to lie on bankruptcy schedules as well. So you're not only facing a possible disastrous result for your business bankruptcy case, you are potentially facing criminal liability for yourself. So all those documents must be thorough and accurate. When you're preparing that petition, what might you need to prepare it? Your profit and loss statement, your balance sheet, your statement of cash flows, AP summaries, AR summaries. All of those documents can be used to fill out those initial pleadings and help, again, establish what a financial snapshot of your business is at point of filing. Finally, the last note on that slide is order for relief. The case really commences with that order for relief. The order for relief should be entered upon the filing of the case. And the most important part of that is that it triggers the automatic stay, which you also heard Eric talk about. Generally prohibits the commencement or continuation of an action or proceeding against the debtor. Again, Eric tapped into that a little bit more. I think anyone who's been involved in this situation knows as your business starts to slide into distress a little bit, your payment times may expand. You may go from 30 days to 60 days, maybe even out into 90 days when you're paying your bills. And as a result, you are probably getting phone calls, emails, letters. Maybe creditors hand over these collections to collection agencies. All of that activity must stop. Automatic stay kicks in. So it's not just lawsuits or actions that are going on in court. It's all of those demands and emails and phone calls. All of that has to stop once the automatic stay kicks into place. And the purpose behind that is really to give debtors some breathing room, right? It's to allow them to address the financial situation at hand and try and resolve it without, one, all the harassing phone calls, but two, without ongoing litigation from 13 different creditors in 13 different sources. So it's a very, very powerful tool in the bankruptcy case and to a debtor. The one thing I will mention in particular about the automatic stay, again, this is a concept that could be discussed for hours by itself, but the one thing I really want to get across is that the automatic stay only applies to the entity or the individual in bankruptcy. Without further order of court, it does not extend to affiliates of that debtor, owners, directors, or officers of the debtor. I have oftentimes heard people try and get away with, oh, well, my company's in bankruptcy, so you can't sue me or my other entities for this money. And that's simply not true. The biggest application of this is probably the personal guarantee. If you have a creditor who's going after your business entity for something, the business entity files for bankruptcy, but you have a personal guarantee on that obligation, simply filing a bankruptcy for the business entity in no way prevents that creditor from coming after the personal guarantor. The personal guarantor would, he or herself, need to file a bankruptcy to prevent that. So be aware of that. I won't spend a whole lot of time on this slide, but just be aware that there is the opportunity for relief from the automatic stay for creditors to continue their actions against the debtor. It is rare, but it does happen, and you need to be aware of it. Penalties for violation of the automatic stay, especially when the automatic stay for a individual debtor can be very, very consequential. So if you are a creditor, be very, very wary of violations of the automatic stay. If you are a debtor, again, make sure that your creditors are aware that you filed for bankruptcy, that they are aware the automatic stay is in place, and that all collection efforts whatsoever need to cease. So what are the different chapters you can file? And we'll talk about a couple of these in more detail in a little bit, but you'll see them on this slide. Chapter 7, Chapter 9, Chapter 11, Chapter 12, Chapter 13, and Chapter 15. We're going to concentrate really on 7 and 11 here because those are the ones that impact mostly businesses. Chapter 9 is for a municipality or cities. Chapter 12, family farmer or family fisherman. I can tell you I've done a handful of family farmer cases, but I have never, living in Chicago, done a family fisherman case under Chapter 12. Chapter 13 is for an individual with regular income, and Chapter 15 are usually for large mega cases dealing with bankruptcies across different nations. But in terms of the process, again, what happens after you file the petition, the involuntary or the voluntary petition has been filed, the automatic stay is in place. The next kind of process or the next event in that process is the meeting of creditors. The meeting of creditors is also called a 341 meeting, named after the section of the Bankruptcy Code which requires it. And it is basically a meeting which will be held in any chapter that you file. So whether you decide to file a 7 or an 11, you will need to have a 341 meeting. A 341 meeting is basically a meeting between the debtor, its representatives, and its creditors to discuss how the business got here, why the business is here, what the business is going to do to try and get itself out of the current situation. You'll see there also the Office of the United States Trustee is in attendance. The Office of the United States Trustee, in case anyone doesn't know, is a department of the Department of Justice. It is there to oversee the bankruptcy process and make sure that the rules and regulations, the Bankruptcy Code and the bankruptcy rules are followed and implemented. You can see the last bullet point on that slide. It really focuses on questioning of the debtor by its creditors, and basically, again, just allows creditors to ask their questions about how and why we got here and where the case is going to go. So let's talk about Chapter 7s really quick. A Chapter 7 is a complete liquidation. The point of a Chapter 7 case is the wind down and end of a business. So the way that the Bankruptcy Code accomplishes that is the owner will actually lose possession of its assets, and those assets will be transferred to what's called a Chapter 7 trustee. A Chapter 7 trustee is then responsible for liquidating those assets, creating a pool of money, and using that money to distribute to the debtor's creditors pro rata. Again, that should sound very familiar to you because Eric just talked about that in terms of the assignment for the benefit of creditors. So he's exactly right. It's very, very similar. The process is very, very similar, but one is inside court, Chapter 7, and one is outside of court. Chapter 11, we'll move on to Chapter 11. Now, entire law school coursework revolves around Chapter 11, so there's no way I can give even a truly brief summary about what Chapter 11 is and does and how it works. But for our purposes, a Chapter 11 is a reorganization case and should be thought of as a reorganization case. It is what allows an entity such as a Kmart or a United or an American to go into bankruptcy, reorganize its debt, reorganize that balance sheet, get rid of some long-term liabilities maybe, and emerge a more lean, successful entity. How does it do that? It remains in possession and control of its assets, again, unlike the Chapter 7. It creates a plan of organization, which is a plan of reorganization, which is a very long, complex document that describes in detail, painstaking detail, how that debtor intends to use its revenue going forward to pay its creditors back over time. And what that ends up with is a confirmation hearing in which the debtor has to tell the judge and all the creditors exactly why they should all vote in favor of this plan, and if that the plan is quote unquote confirmed by the court, and that is basically a contract which the debtor must abide by in terms of repaying his creditors over time. Now, again, I don't have time to go over every nook and cranny of Chapter 11 because it's far too large, but the one I really wanted to concentrate on for our purposes is this next one, which is the unexpired lease treatment under Section 365 of the Code. And basically what Section 365 allows is the assumption or rejection of executory contracts, or, in the purposes of what we're talking about today, unexpired leases. So as part of that, you need to know that clauses in leases or contracts which say they are terminated automatically upon the filing of a bankruptcy are unenforceable in bankruptcy. Those are called ipso facto clauses, and you can see that bullet point in my slides. Ipso facto clauses are unenforceable. So the bankruptcy court, first off, knocks that clause out of a lease in this instance. then a debtor is allowed to decide whether or not that unexpired lease, in fact, a benefit or a drawback to its business. If it is a drawback, it is allowed to reject that contract. If it is a benefit, it is allowed to assume that contract. So that is a huge power that the Bankruptcy Code gives debtors in Chapter 11 cases. For example, the quick one that I give a lot is if you have entered into a long-term lease at a very high rate, lease rates have then plummeted or crashed, you find yourself in a Chapter 11 case, you may be able to reject your high rent lease and go find new space at a much more amenable, workable operational level through Section 365. Of note there again, CBAs under 1113 can also be rejected or assumed under some different scenarios, but just so we all know that the CBAs do have that same capability. Now, I want to spend just, the remaining amount of my time, and really what I want to focus on here is on the SBRA. And the SBRA is the Small Business Reorganization Act. It created what's called a Subchapter 5 of Chapter 11, and it is a brand new subchapter of Chapter 11 designed specifically for small businesses. And as you heard Eric point out earlier, depending on what statistic you use, upwards of 95% or higher of all businesses in the United States are defined as small businesses. So this is really an effort by Congress and practitioners to make the Chapter 11 process a little more workable, a little more efficient, a little more available to small business debtors. You can see my next slide, which is eligibility. The most important part of that is the small business debtor is defined in the SBRA as a debtor having secured and unsecured debts of not more than $2.7 million. Now, there's been a lot of talk in the industry about that number and if it's too low, but for the moment, we are excused from having that argument because in the time of COVID, the CARES Act came along a couple months ago and increased that debt limit up to $7.5 million. So for the next year, small businesses, in terms of the SBRA, are defined as, in general, those small businesses which do not have a liabilities exceeding $7.5 million. As I mentioned, though, in 1 year, that cap is expected to expire. Let's talk about the major provisions of Subchapter 5, because again, I think it's going to be probably the most applicable option for most small businesses seeking to reorganize under the Bankruptcy Code. It requires the appointment of a Subchapter 5 trustee. Now, we heard us talk about the Chapter 7 trustee earlier. There's also something called a Chapter 11 trustee. In those situations, those trustees actually do take possession of the debtor's assets and they run the business. I don't want anyone to get that misimpression under Subchapter 5. A Subchapter 5 trustee absolutely does not take possession and control of the debtor's assets. A Subchapter 5 trustee has completely different duties and responsibilities, which we'll talk about a little more in a second, but it's much more of a supervisory consultation role than that is in a Chapter 7 case. As I mentioned, this entire chapter, the purpose of the chapter is to make it more available for small businesses. As in part of that, they wanted to reduce time frames and deadlines. Anyone who's ever been involved in a Chapter 11 case, especially a case such as Caesars or United, these cases can go on literally decades. And for a small business, that's simply not a viable option. They don't have the kind of time or money to be involved in that kind of process. So one of the great points of the SBRA is it reduces drastically those time frames and deadlines. It also changes some confirmation requirements, which we'll talk about in a second. But moving on to the Chapter 5, Subchapter 5 trustee, you'll see there, as I pointed out, the debtor actually remains in possession of its assets and operates the business, not the Subchapter 5 trustee. Again, I can't stress that one enough. But what is the Subchapter 5 trustee supposed to do? It's supposed to supervise the process and assist in coming up with a consensual plan. One of the things that makes the SBRA and the Subchapter 5 process so attractive is that there is a big push on behalf of both the legislation and bankruptcy judges, which are interpreting this new statute, to come up with consensual plans. Consensual plans make the whole process quicker, less expensive, and easier to get the small business up and running again. So one of the main tenets of the SBIRA is the consensual plan, and that is one of the real hallmarks of what the Subchapter 5 trustee is supposed to be doing. We'll just skip ahead a little bit. So timeframes and deadlines. As I mentioned, Chapter 11 cases in general go on for years and years, if not decades. You'll see right here, mandatory status conference not later than 60 days after the order for relief or the time the case is filed. So 2 months in, and you're already having a status conference about what's going on. And that status conference is to, quote, further the expeditious and economical resolution of the case. So again, 2 months after filing, and the judge already wants to know what we're doing to get out of this case. That's a very, very big difference from the Chapter 11 practice in general. In addition, 14 days before that status conference, the debtor is required to file a report, which, quote, details the efforts the debtor has undertaken and will undertake to attain a consensual plan of reorganization, unquote. So again, we see statutorily this mandate that they want to see consensual plans. They want to see the debtor, its creditors, and the Subchapter 5 trustee working towards that consensual plan. Another time frame, debtor alone can file a plan and must do so no later than 90 days after the order for relief. So again, comparing this to another, a large Chapter 11 case, where you may not see a plan for years and years and years and years, we're 3 months into this SBRA Subchapter 5 case, and by statute, the debtor has to already file a plan. No disclosure statement unless the orders otherwise. The disclosure statement is just another very large, complex document which helps explain the plan of reorganization. In a regular Chapter 11 case, the plan and disclosure statement can be thousands of pages each. Again, make it very, very complex, complicated, and not really available to a normal small business debtor. So confirmation issues, I won't get too into the nits and of the 1129 process, but the point of this first slide is that all of the obligations in the regular Chapter 11 apply in the Subchapter 5 case. If all those elements are met, the plan is consensual and should be confirmed. That's the same thing that happens in the Subchapter 5. Again, that's what we're shooting for. We're shooting for a consensual plan. But what happens if the plan is not consensual? Subchapter 5 changes that up a little bit. Non-consensual plans in a Chapter 11 case can involve lots of hearings, lots of fighting. They're sometimes called a contested confirmation hearing. Those things all can happen in a Subchapter 5, but in a much more brief manner. In addition, Subchapter 5 is allowed confirmation even if every single class of creditor votes to reject the plan. Now, that's a major difference from the normal Chapter 11 process. As I mentioned earlier, kind of the point of this plan process is the debtor goes out and solicits votes to accept or reject its plan. That plan then gets confirmed or not confirmed. In a Chapter 11 case, if you don't have any consenting classes, any classes that accept that plan, a debtor is not allowed to get that plan confirmed. Subchapter 5 changes that up. Again, they want to make that the purpose of this legislation is to make it more attainable for a small business. They want to make the discharge, the ongoing operations of this business much more attainable for a small business. The other really, really important part that differs from Chapter 11 practice in the Subchapter 5 context is that it eliminates the absolute priority rule. And I won't spend too much time on the absolute priority rule, but basically what it means is that junior classes of creditors, for example, ownership, right, the equity, the people who own that business, cannot receive property from the estate of the debtor unless every single class above it or ahead of it have been paid in full. Now, obviously, for a small business debtor, that's going to be a problem. In a case like United, if ownership, the owners of the shares lose their shares, probably not a big deal. There's millions of people out there. Obviously, it's a big deal. I shouldn't say that. It's a big deal to people who own that share, but the ownership is not a mom and pop or a family or a small group of individuals. It's millions of individuals. Previously in Chapter 11, it was very complicated for small businesses, especially with a few owners, to survive the absolute priority rule because they couldn't pay all of their other creditors in full in order to be able to retain their equity ownership. So they did not want to file a Chapter 11 case for fear of losing control of their business at the end. That problem has been eliminated by the elimination of the absolute priority rule in the Subchapter 5 case. So again, another really powerful tool in this Subchapter 5 case. Cram down, again, I won't spend too much time on, but again, cram down is the process by which a Subchapter 5 business can confirm its plan even if every single creditor does not vote in favor of that plan. These two slides kind of lay out how that can be done, and I think we're running out of time, so I don't want to spend too much time on it. It does get a little technical, but that's one of the points where we can have the Subchapter 5 assist the debtor, the Subchapter 5 trustee assist the debtor. If the Subchapter 5 and the debtor come up with a plan that they think is fair and reasonable and doesn't discriminate, provides for the disposable income of the debtor to go towards repayment, is feasible and has some sort of enforcement mechanism in that plan, and both the Subchapter 5 trustee and the debtor report that to the judge in the context of a confirmation, a bankruptcy judge will go ahead and confirm that plan even though every single other creditor objects to that plan. And that's kind of the cram down provisions again, which is a little different in the Subchapter 5 context than it was in the regular Chapter 11 context, and which gives debtors, I think, a lot more power in the Subchapter 5 context than the regular Chapter 11 context, and which should lead to a higher use, we're thinking, of this Subchapter 5 process as opposed to the regular Chapter 11 process. The last thing I kind of want to mention is this last slide here I have now in front of you, which is the enforcement mechanism. In terms of creditors, it's not all debtor-centric, the Subchapter 5. One of the pushbacks they gave to creditors in this process is reflected in the slide right here. And that's basically that the plan has to provide appropriate remedies if the debtor fails to do what it's supposed to do for its Subchapter 5 plan. So you'll see a quick reference in there, which may include the liquidation of non-exempt assets. So from day one, the creditor going into this case may know if and when this debtor misses its payment, I can do X, Y, and Z immediately. I don't have to run back into court. I don't have to do this and that. It's laid out in the plan what I can do, what my remedies are the second a default happens under that plan. So while the Subchapter 5 process, I think, is truly aimed at beneficial to small businesses, there are little gives and takes in there that I think will benefit creditors as well. And they shouldn't really bother the Subchapter 5 debtor if the Subchapter 5 debtor is really doing what it is supposed to be doing under the case. So the final thing I want to talk about is administrative expenses. Administrative expenses are any and all expenses that accrue during the course of a Chapter 11 case. Those paid according to a Chapter 11, a regular Chapter 11, at basically the effective date of the plan or the date the plan is confirmed. Now, for those cases that go on for years and years, the amount of that administrative expense can be massive. Even in the 3 or 4 months that a Subchapter 5 case might run, the administrative expenses could be a very large number. As I mentioned, in a regular Chapter 11 case, all of those payments would have to be made at confirmation of the plan at once. At least they should be technically. Subchapter 5 case, again, realizes that small business debtors are not really able to do that. They don't have that kind of cash flow. They don't have that kind of immediately available liquidity to make those large payments. So it does allow those administrative expenses to be spread out over the life of the plan, much like any other creditor. So again, this is a major step forward in terms of what it allows small business debtors to do in the context of a Subchapter 5 case. Mm-hmm. And whereas that payment would be probably prohibitive for most small business debtors in a Chapter 11, it makes it much more approachable in the Subchapter 5 context. And those are just takeaways we kind of talked about earlier. Yeah, go ahead.
Sorry. Bill, just a quick question that might be on the audience's mind. Can you give, and of course it depends on the company and the size of the debtor, but could you give maybe some ranges of what a typical, if there is such a thing as typical, Chapter 7 case would cost versus a Chapter 11, just to give the audience some idea of the range?
Sure. A Chapter 7 case can usually be done maybe in the $5,000 to $10,000 range, all in. Again, Chapter 7 doesn't have the administrative expense provision that Subchapter 5 does, so that would all have to be paid up front. I'm sure you'll find some, maybe some smaller shops that will do Chapter 7 cases for businesses less than that. We don't do them for less than that at Smith Amundsen. But if you compare that to a regular Chapter 11 case, where you're literally talking hundreds of thousands of dollars, if not, obviously for the Uniteds and the Caesars, you're talking hundreds of millions of dollars. I've seen fee applications in those cases for several months, which are, $12 million, $13, $14 million a month. So it's really hard to pin that down. It could be anything. For kind of my practice, I would say the Chapter 11 case, the regular Chapter 11 case is probably several $100,000 from start to finish. The Subchapter 5 case, however, should be markedly less than that. I'm hesitant to give out a number because it all depends on a lot of things, but it will be more than the $10,000 for the Chapter 7, but certainly less than the $400,000 for a regular ongoing Chapter 11 case.
Okay, thank you.
Yep, and that's it. That's all I have.
Okay. Well, thank you, Bill. That was an excellent presentation. I think we do have one question from the group, and Bill, I'm going to ask you about this. Let me just here. The question is, with respect to the 90-day look back for a fraudulent conveyance and recapture of money back into the debtor, is there a rule, take COVID for instance, where nobody expected COVID? So if a business has to go into bankruptcy because of COVID, or even in ABC, is the 90-day look-back rule relaxed somewhat because nobody anticipated this calamity occurring?
Okay, it's a good question, and I want to clarify a couple of things. The 90-day look-back period is for preferential transfers, and a preferential transfer is really any payment made by a debtor in the 90 days before a bankruptcy case was filed. So any payment, period. Now, there are defenses to that, but if that payment was made in the 90 days before bankruptcy, it is automatically a preference. Fraudulent conveyance law is a little bit different. Fraudulent conveyance law, under bankruptcy law, a fraudulent conveyance look back is 2 years, can be stretched up to 4 years according to state law. In Illinois, it's 4 years for fraudulent conveyance. And some would argue, and this is hyper-technical, so I don't need to get into it, but some would argue the fraudulent conveyance look-back period could extend to 10 years. But the quick answer, it's probably not quick anymore, but the answer to your question is no. There are no, right now, modifications or amendments or supplements to the bankruptcy code term limits on what a preference is, what a fraudulent conveyance is, and what the defenses are. I don't see that changing anytime in the near future, simply because of what we're trying to accomplish by the preference statute and the fraudulent conveyance statute. But anything is possible. But as of now, no, there are no COVID exceptions to those 90-day look-back periods.
And in the case of an assignment for the benefit of creditors, would the same rules apply, or would an assignee have any more flexibility to relax those rules somewhat?
Again, there's no real preference in the ABC context. It's just state law for fraudulent conveyance. So the state law is what the state law is, unless the legislature passes some sort of amendment or supplement or forgiveness then the law is what it is. And anything that fits within that definition in the 4-year period is going to be a fraudulent conveyance. I have not seen any efforts as of yet to change the laws on what a fraudulent conveyance is or is not, or give any kind of forgiveness on what it is or is not as of yet.
Okay, thank you. And thank you to our audience for joining us today. And on behalf of Mike, Bill, and myself, I'd like to thank everyone for attending our webinar. And we know that financial distress can be particularly scary and lonely challenge, and that there are not many people that you can talk to and trust. So we're here to help. If you or anyone you know would like to discuss your business's current situation, please do not hesitate to call me, Mike, or Bill. Thank you for your attention and have a good day.